Now we're going to talk about the requirement that there be a legally recognizable injury, and also the requirement that the negligence, the act of carelessness, is both the direct cause and the proximate cause of the injury. So first, with regard to legally recognizable injury, we've already said usually if you get your feelings hurt or there's a careless infliction of emotional distress, that does not rise to the level of an actionable injury, and you will not recover damages. You can recover damages for real physical injuries. On rare occasions, someone might recover a little bit for emotional suffering if, say, a mother sees her child injured or killed in a traffic accident. She might recover something. But for carelessness that causes embarrassment or insult, usually no, you can't recover. So what kind of damages can you recover in a lawsuit for negligence? Well, you can recover for your medical bills if you're injured. If you lose work time because of the injury, you can recover your lost wages and your lost employee benefits. You may recover a little bit of compensation for your physical pain and suffering, and maybe a little bit of emotional suffering, but not usually. But there's one kind of damages that usually you cannot recover in a negligence case, and that is punitive damages. As a general rule of law, we do not punish people for being careless, because carelessness is usually not an intentional wrongdoing. There is one exception to that, though, and that is if the negligence that was involved was gross negligence, that is reckless disregard for the safety of others, then you may be able to recover punitive damages also. But the general rule is no recovery of punitive damages in a negligence case. Now we get to some really interesting legal argument, and this is an area where many lawsuits for personal injury are won or lost, and it is the issue of causation. We've already said that the act of carelessness, the negligence, must be both the direct cause and the proximate cause. And you say, well, what are we talking about? Well, let's go through it. The direct cause means that your injury would not have occurred if this person had not engaged in whatever the carelessness was that he engaged in. So the test, the legal test for whether or not an act of carelessness is the direct cause of your injury is what is called the but-for test. So if we go back to my example about my failure as the teacher to clean up the 60-ounce spilled Slurpee on the classroom floor, but for my failure to get that cleaned up, my act of carelessness, would you have slipped and fallen and broken your hip? If the answer is no, but for my carelessness, you would not have been injured, then my carelessness is the direct cause of your injury. So the test to determine whether or not the carelessness is the direct cause of your injury is the but-for test. But the proximate cause test, it must not only be the direct cause, but also the proximate cause. And the proximate cause is a little more, shall we say, sticky to figure out than the direct cause. But it's not complicated. The proximate cause simply says, is it reasonably foreseeable that this type of carelessness could have caused that kind of injury? If it's reasonably foreseeable that my failure to clean up the spilled Slurpee could cause a person to slip and fall and be injured in a fall, then yes, I'm not only the direct cause, but I'm also the proximate cause, and so the plaintiff should be allowed to recover. What really helps, I think, for a student to understand the proximate cause concept is to go back to the original proximate cause case, which goes back to the 1800s and the railroads. It's a fascinating case. Usually I do this with drawings, so I'm not sure it's going to work without the drawings, but what we had in the Palsgraf case, we had P-A-L, and then I can never remember whether there's an S in there or not, but it's P-A-L-G-R-A-F or it's P-A-L-S-G-R-A-F. And since I'm in the motorhome camping today and my battery died on my laptop, I can't check it. I'll check it later and put it in the written material. But the Palsgraf case happened at a railroad station, a train station. This is back in the days when there were no cars and trains ruled the world. And so the train is pulling out of the station, and there's a passenger who's late. He's about to miss his train, and the train's pulling out, and so he runs after the train, and he tries to jump onto one of the little back platforms on one of the passenger cars and get onto the moving train as it's leaving. A conductor who's standing on the platform on the railroad car sees the man running and trying to get on the train, so he reaches down, grabs hold of the man, and helps to pull him up onto the train. There's another railroad conductor who's on the train station platform. He sees the man running, trying to get on the train, so he runs up behind the man and gives him a boost from the back so that he can get up onto the train. Well, the running man successfully gets up onto the train late, and you would think everything was going to be great, it's all good, and the man is safe, but there's a problem. And the problem is that when the man was running to jump onto the train, he had tucked under his arm a large package wrapped in a brown paper wrapper, and as he jumped onto the train, that package fell out of his arms onto the railroad track. And the next train car coming behind his ran over that package. The package was filled with fireworks that he had bought for his children, and when it got run over by the train, it exploded. When it exploded, way down at the far end of the train station platform, there was a big big metal scales that was used to weigh baggage. And when the package exploded, the shock wave from the explosion caused that metal baggage scales to tip over, and it fell over on poor Mrs. Palsgraf and caused her some serious injuries. So Mrs. Palsgraf sued the railroad company. The passenger was gone on the train, and she said these two conductors, by helping a man to run onto a moving train, jump onto a moving train, they were engaged in an act of negligence, and as a result of that, she ended up getting injured, so the railroad company should have to pay all of her medical expenses. But the railroad company, and remember this is back in an era when the railroad companies pretty much owned everything, the railroad company said, well, Judge, you know, we're sorry Mrs. Palsgraf got hurt, and yes, maybe our railroad conductors were being careless by helping a guy move on to a moving train, but you could also argue that they were exercising safety. They were trying to keep the passenger safe when he was doing a foolish thing. And besides that, it's just not foreseeable that Mrs. Palsgraf's injuries would be the result of helping a passenger jump onto a moving train. I mean, it's foreseeable that the guy jumping onto the train could have fallen and gotten hurt, but is it foreseeable that a guy jumping onto a train, because the conductors helped him, he dropped a package and the package was full of fireworks, and the fireworks got run over by the following train car, and the fireworks blew up, and way down on the far end of the railroad station platform, metal scales tipped over, and it hurt poor Mrs. Palsgraf? That's just too far removed in the chain of events to be reasonably foreseeable that that type of injury could result from that act of carelessness. And the judge said, yeah, you're right, and dismissed the case. And so that's the famous Palsgraf case. And from that time forward, if you want to win your lawsuit for negligence, you have to prove not only was the carelessness the direct cause of the injury, but it was also the proximate cause of the injury. The test for proximate cause is reasonable foreseeability. Is it reasonably foreseeable that that type of injury would result from that type of carelessness? I personally have always wondered about something that's never explained in the Palsgraf case, and that is, wait a minute, who owned the big metal baggage scale that tipped over and hit Mrs. Palsgraf, and was it properly built so that a shock wave would cause it to tip over and injure her? If the scale was owned by the railroad company and it was improperly made, you know, maybe they should have paid Mrs. Palsgraf anyway. But I guess history, that's lost in the annals of history, and we'll never know.